been approved by the LSP board for 1.5 credits, so don't forget to pick up your signed CPU forms. The registration table's on your way out. I know Matt had some issues there, and we'll try to make sure everybody gets what they need. If anyone doesn't receive one at the end of the night and was here, please reach out to Matt or myself or Wendy. Actually, maybe even April. So I'd like to introduce Michelle O'Brien. She's an attorney and partner at Piers Atwood. She's a longtime member of the LSPA's Loss Prevention Committee. She'll introduce tonight's program, which is an update from the Board of Registration of Hazardous Waste Site Cleanup Professionals. Thank you. Michelle.
Thanks, Kevin. I'm actually going to use the roving mic, but it would be helpful if you could go back. Because we're not just going to talk about these things. Where is the...
Yeah, a little clicker thing across there.
Okay, we're done. Okay, and we're starting on time for those of you who are paying attention to the 1.5 credit hours for this. Thanks. Thank you, Kevin, for the introduction. I'm Michelle O'Brien, and as Kevin said, I'm an environmental lawyer at Piers Atwood in Boston. I'm a longtime member of the Loss Prevention Committee, and loss prevention, as many of you know, has as its goal to help LSPs prevent loss. So keep you out of trouble, at least on a professional side, as much as possible. So we thought it would be a good idea to present, because we haven't heard this talk in some time, an update on the Board of Registration of Hazardous Waste Site Cleanup Professionals, also known as the LSP Board. And as you know, the LSP Board is the licensing board for LSPs, and is also responsible for investigating complaints filed against LSPs, and also for imposing discipline upon LSPs who fail to comply with the rules of professional conduct. I'm joined this evening by 2 members of the LSP board, Gail Batchelder and Jack Guswa, who will participate in the presentation this evening, and also the board's executive director, Beverly Coles-Roby. And while I'm just switching to the next slide, there are a number of LSP board members here. If you would just stand so you can be recognized and so people can recognize you. Thank you all for being here as well. So this evening, I think it's pretty obvious I'm doing an introduction. And Beverly will cover the board member overview and the rules of professional conduct. Jack will discuss the complaint review process. And Gail will talk about types of discipline and disciplinary action statistics. Hopefully we'll have time for some case studies that will help you understand better why and when the board imposes discipline. And we want to obviously allow plenty of time for questions and answers at the end. So I'm, in addition to moderating, I'm going to try to be a timekeeper this evening. We thought it would be helpful to hold questions until the end. Hopefully some of your questions will be answered throughout the course of the presentation, but obviously we want to make sure we get through the entire presentation. We also have index cards, and I'm going to actually bring them to the back when I turn the program over to Beverly in a moment. So perhaps that will save a little time in the Q&A process at the end. If you have questions, sometimes it's helpful, I think, to write them down as the presentation is going forward. So jot down your questions. You can hand them up at the end of the program. I'd be happy to ask the questions of whomever, or if folks want to raise their hand, that's obviously fine too at the end of the program. But I have the stack of index cards here, but I'll bring them to the back of the room or hand them around so folks can have them while the presentation is going on. So the bios of each of the presenters, including mine, is in the materials that were the staples, just the 2-page stapled sheet that was at the registration table. Hopefully you have it. If not, it just contains the bio and the agenda. So no big deal if you don't have it in front of you, because I won't spend time going over bios. Obviously, we're all, and you are all, very accomplished people. And with that, I'm going to turn it over to Beverly to get started. Thanks.
Turn this on. Thank you, Michelle. Am I being heard all the way in the back? No? Yeah, not so good. Testing.
There you go.
Got it. First of all, welcome everyone. It's wonderful to see you here. I'm given to understand there are 98 LSPs here. Yes? No? Some? All right. Well, the first thing I want to preface my remarks by inviting you all to attend a board meeting. All the meetings, as you know, are public, and we'd love for you to attend and participate. We circulate throughout Massachusetts, so our next meeting is in Nero. They're always at DEP, Mass DEP offices, so please, at some point, join us for a meeting. Okay. So, how many of you are there? There are 545 licensed LSPs in Massachusetts. We have one person who is on inactive status. And I'm going to refer a lot during my remarks to the regs because, as I call them, they're my Bible. I don't have the latest version on.
I'm sorry.
Somebody take care of that. All right. So I'd like for you to take a look at 309 CMR 9.00 if you're interested in becoming an inactive member. I'm only going to say a couple of things about that. First of all, you have to notify the board, of course, and then you have to notify DEP. You cannot act as an LSP, hold yourself out to be an LSP, or advertise. You still have to pay your annual fee. Any courses that you take during the 2-year limitation on inactive status can be used toward your continuing ed credits once you become active again. So, how did this happen? How did we all become linked through the LSP board? The genesis of the LSP board came through the movie A Civil Action. Has anyone ever seen that? John Travolta, the Woburn. Okay, the state at some point after that decided that it just couldn't handle all of the hazardous waste sites in Massachusetts. It was absolutely impossible. It was such a small number. So it decided to create this privatized program that we're now all a part of. We are under the aegis of the Executive Office of Energy and Environmental Affairs, but it's kind of a strange hybrid because we're actually physically housed at DEP. We are employees of DEP, except for the 10 board members who are appointed by the governor. And I briefly want to talk a little bit about the process because I don't want this to be a big secretive thing because it's really not. The appointment by the governor only comes through the board. We recruit. We do have a vacancy if someone is interested. It's an environmental position, and you can see any board member if you want a more complete description. But we recruit through the LSPA and other means. We interview candidates. We make recommendations based on the interview to the commissioner. The commissioner makes a decision on our recommendations, the commissioner of DEP, that is, and forwards them to the secretary of the executive office. And the secretary of the executive office makes a decision, the final decision about what goes up to the governor's office. There is a background check that's involved, and people serve for 4-year terms. This is a list of the board members. I won't go into their backgrounds because I want to urge you to take a look at our website. Complete biographies of all the board members, our very experienced folks, are posted there. There's the vacancy down at the bottom that I was talking about. If you will notice, there are 5 LSP slots. 2 of them are particularized. There's a manufacturing slot, and there's a slot for a person, an LSP who works in the area of petroleum. Board member responsibilities. It's a volunteer board. We ask a lot of these folks, actually. It's not just the monthly meeting. It's a lot of paperwork that they review and careful consideration that they give to things that affect you in a number of areas. So some of the things that they do are evaluate applications for licensure. There is that process starts with recusal forms. So no board member reviews the application of someone that they might be a little too close to, or for whom there might be the appearance of a conflict of interest. We meet before every board member, before every board meeting rather. Each application is considered separately. Each application panel, board members volunteer to sit on those panels. There are 3 members who sit on the panel and they make one of 3 decisions. They approve the application, they deny the application, or they table the application for further review. Most often, they're sticking to the regs. When they look at these applications, they're looking for these things that are also defined in the regulations as 3.309 CMR 1.00, total professional experience, relevant professional experience, and most importantly, they're looking for applicants to be principal decision makers in the area of waste site cleanup. Tip for anyone who's thinking about applying: the pet peeve of the application review panels is typographical errors. Everybody needs an editor. I have one. I use Lori, our investigator, all the time for that purpose. Once you look at something so many times, you really can't see the mistakes in it. So if you're thinking about applying, please have someone review it. Board member responsibilities. The continuing ed courses, I just want to say one thing about that. The board members are always looking at the continuing ed courses with the idea in mind: how is this going to help an LSP improve what he or she does? I want to say one word about investigating and prosecuting complaints. When we drafted this slide, a board member said, "Oh, prosecute, I don't like that word. That's so severe." But it's a harsh thing. It takes a lot of consideration on the part of the board members to arrive at the conclusion that someone has committed malfeasance, that someone has done something inappropriate, or that someone needs to lose their license. But the word prosecute also means that LSPs who are alleged to have performed badly or committed some wrongful act have a property interest in that license, and they have a right to have notice of what the allegations are, and an opportunity to be heard, an opportunity to defend themselves. And I'm just trying to impress upon everyone that discipline, that you're going to hear a lot more about later, is something that the board does not do lightly. I'm sure there are a lot of sleepless nights for some of the members who make these decisions. I'm not a voting member, so the onus is most often on the board members. One word about imposing discipline. Most often, discipline is based on precedent. The board has a historical record of all disciplinary measures imposed, and they look at those. They look at those for similar sets of facts, for similar sorts of violations of the MCP, and they compare the case before them with what's happened or what the discipline that's been imposed before. So again, really careful consideration, not to mention the historical aspect of imposing discipline. Grounds for discipline. LSP must act with reasonable care and diligence. What does that mean? It's kind of like, what would a reasonable LSP do under this particular set of circumstances? defined, but we know it when we see it. The factors that affect whether or not an LSP acted with reasonable care and diligence are professional competency, professional responsibility, and I just wanted to do a little legal speak here with respect to professional responsibility, because these terms are really codified at 309 CMR 4.03. And in most cases, it's common sense. You'd never do anything without keeping your client notified of what you're doing. I most often advise people when you say, because things change over time, the story once it's been told, that sort of thing, always advise your client in writing. There are some times when people think you said one thing and it turns out you said something completely different. Notifying your client in writing is the best way to go. So 4.03, specifically subparagraphs 1 through 3, detail professional responsibility. Conflict of interest is a little more difficult for folks to navigate sometimes, and I think that sticking to the regs is the best way to deal with that, and that's at 4.04. Financial interest, business associations, those sorts of things, you have to notify your client. So you want to be very careful about recognizing a potential conflict of interest. This one, again, is very difficult to define. It's what is a conflict of interest? You really want to think whether or not this is going to raise eyebrows. It's kind of simple. In theory, in practice, it's much more difficult. What would raise someone's eyebrows? What would cause them to think twice about what you've done or what you've said? So again, I'd like for you to take a closer look at the regs. Accepting compensation, another tricky area. If you're working for one client and accepting payment from that client, clearly if you have another client involved in this process, you want to keep both clients apprised of what's going on. If there's a financial interest or something that might affect the outcome, you want to make sure everybody knows everything, no sudden moves. Everybody has to know everything that's going on. I think conviction resulting from a felony or a misdemeanor is pretty self-explanatory. Don't do that. Don't do it. Professional competency. Again, we're back to the reasonable person standard. You want to apply the knowledge and skill ordinarily exercised by an LSP in Massachusetts. It's the reasonable person standard. This rule does allow you to rely on other qualified professionals, risk assessors and such. I would caution you to make sure that you know who, if you're relying on some other professional, that you know where they were trained and how they were trained and what their level of experience is. Because relying on someone who doesn't have the training or the experience is not going to be taken by the board as reasonable. I think the last bullet point is pretty self-explanatory. Of course, you're not going to rely on a predecessor's opinion without having reviewed every single thing before you render your opinion. These things are, again, self-explanatory. I know I keep saying that. I sound a little like Marco Rubio here, huh? Sorry, it's New Hampshire. Everybody's voting today. We want to know what happened. Yeah.
It's over, they've already voted.
They did?
Well,
the
it's
polls-
after 8.
Yeah. The polls closed at 7. Polls closed at 7. We'll find out soon
It's only
enough.
7?
Again,
My watch is wrong.
the good thing about these regulations is that they are intertwined, that a lot of thought was put into setting these regulations. So if you look at bullet point 2 where it says exercise independent, professional judgment, I mean, that goes back, everything I think harkens back to the reasonable person standard. It's not reasonable to rely on someone without exercising your own professional judgment. Again, number 3 there, follow the MCP. What else are you going to do? Make a good faith effort to obtain all the data that you can before you render an opinion. What else can you do? You have to have that. And disclose information that contradicts your opinion to your client. Conflict of interest. Again, I sound like Marco Rubio, but keep your client in the loop. Significant conflicting or adverse interests have to be disclosed. If you have a financial interest in something that is part of your LSP work, you have to disclose that to your client. And again, the reasonable person standard is articulated at bullet point 3. Is the circumstance substantial enough to create an impression of influence? And no one would ever solicit or accept financial consideration from suppliers. So, enough said. Accepting compensation, an LSP cannot allow ownership, interest, compensation, or continued employment to affect your professional services, and I absolutely know that no one in this room does that, so enough said. I'm going to turn it over to Jack now. Thank you.
So how do we advance this?
Can you just touch anywhere?
This one?
Well, scroll down.
Oh, up and down arrows, okay, thanks. That's what it is.
Touch the,
The right hand.
anywhere on the screen. Yeah.
Go. Okay. So thank you, Beverly.
You're welcome.
So I'm going to spend the next few minutes giving you a high altitude but hopefully informative discussion of the complaint review process, and I'll walk you through the sequence of steps that basically and talk about the main events in that process. So wrong direction. So we're not going to have to look at this, but I just wanted to point out that people probably heard about the flow chart. Some people even will probably try to decipher or interpret the flow chart. And so there is a pretty detailed process that is followed to go from A to Z in the disciplinary process. But there are 3 main components. One at the top is where the complaint is filed and the initial actions taken with the complaint by the board staff. And then the second major milestone is called the complaint review team, and that's where the substantive investigative work takes place. And then if you get to the third major milestone, that's the adjudicatory hearing, which is a formal hearing. But this flow chart provides a roadmap through the process. I'm not going to speak directly to that slide, but the following slide identifies the key processes and specific regulations. So 309 CMR 7 is something that you should take the time at some time to review and read, because it's a It's not your most exciting reading, but it does explain everything that you as an LSP need to understand or know in terms about the various steps in the disciplinary process. And the first 6 bullets on this slide, they refer to the complaint review process. This is a disciplinary process slide. The first 6 refer to the complaint review process, and then the last 2 basically refer to if you've lost your license, how do you get it back? And then secondly, if you've lost it for more than 90 days, what are your obligations with respect to reporting to your clients? But I'm just going to basically focus tonight on the top 6 bullets here. So there's 6 components here. So I'm going to talk about the complaint initiation, the board staff review. This is a preliminary review of the complaint. Then the board professional conduct committee review, and for organizational reasons, all members of the board are actually members of the professional conduct committee as well, but there's a formal period where the professional conduct committee meets. And so it's the professional conduct committee that essentially does the review. We then have a screening team or a complaint review team. I'll explain that process. And then the board member review and determination of whether or not discipline is warranted and what that discipline would be. And that would only be for non-recused board members. I'll talk about that in more detail. And then if you get to the end, you have the adjudicatory process, which is a formal hearing. Now you're going to come to learn later that about 50%, only about 50% of the complaints that are filed actually result in some type of discipline. Approximately 50% are dismissed at some time, either before, immediately after, initially during the initial review, or sometime during the process they are dismissed. All right, so let's go through the process. So the first thing is the first step in the complaint review process is getting the complaint. And any person can file a complaint, and they can file it at any time and for any reason. And there are no restrictions, therefore, on who may file the complaint. There are, however, restrictions on what complaints the board may review. There are certain complaints that have been filed that are clearly not within the jurisdiction of the board. And the board staff does an initial review to basically exclude those as soon as possible. A fee dispute, for example, is a type of complaint that can be filed, and the board has no jurisdiction over that. Is not a basis for us to make any evaluation on that type of complaint. So the board staff do that preliminary screening to weed out the complaints that should not go to the board. But if the board staff or the board investigator does reach the conclusion that a complaint should be reviewed by the board, then it goes to, they notify the LSP, they provide the LSP with a copy of the complaint, and they request the LSP to respond to the complaint. Now, you're not under any obligation to respond to the complaint, but if you do find yourself in that situation, you should be viewing it as, this is my best chance to provide a response to the complaint and provide relevant facts and information that would hopefully, for your purpose, convince the board that there was no validity to the complaint that was filed. So I think sometimes people get notified that their complaint has been filed, and their first reaction is, oh, this is ridiculous, I'm not going to, and sometimes they don't necessarily take the time and effort to take it as seriously as they should and take advantage of the opportunity to assist themselves in getting the complaint dismissed, assuming the facts would support dismissal. So anyway, if you find yourself in that situation, don't underestimate the importance of responding to the complaint when you're asked to by the board. But after the LSP, after the complaint and after the LSP response is received back by the board, both the complaint and the LSP response, and the response can be a summary letter, or can be a letter, and also backup documentation, facts, data, whatever, that you as an LSP want to include. Those documents are redacted, and they are sent to the Professional Conduct Committee for review. And the redacted complaint and response is reviewed by the Professional Conduct Committee just for the purpose of saying, is there a belief that discipline may be warranted in this matter? And the identity of the LSP and the identity of the site and the identity of the complainant are not known to the Professional Conduct Committee at this time. So this is a truly, that's not random, but you know, you have no information about. It's an unbiased review of the supposedly an unbiased review of the complaint and the response. And there are three general outcomes that can come out of the Professional Conduct Committee. One is to dismiss the complaint. So the Professional Conduct Committee reviews the complaint, they review the response, they have a discussion, and then basically there's a vote taken, and it's either dismiss the complaint or we need to do something more. Now, the two things that could be something more, one is if it's a little bit difficult to know whether or not discipline may be warranted, we can form a screening team. And the screening team consists of 3 members, a board attorney, an LSP member of the board, and a non-LSP member of the board. And the sole purpose of the screening team is to do a limited review of additional information to help resolve the issue as to whether or not a complaint review team needs to be formed. So this is not a full investigation done by the screening team, but in the course of the initial deliberations by the Professional Conduct Committee, there may be some saying, I wish we knew a little bit more about this claim and this response to the claim, and so you can focus on a few key documents, and that's what the screening team does, and then they make a recommendation as to whether or not a complaint review team needs to be formed. So, and the complaint review team is the more substantive team. That's where the bulk of the investigative and evaluation work is done by the licensing, by the board. It's done by the complaint review team, which also is board attorney, an LSP board member, and a non-LSP board member. And in many cases, the CRT may be the same as the screening team, but not in all cases. And the reason for that is this is going to be the first time that any member of the board is informed of the identity of the LSP and the site. So we get a group of 3 that's the nominated or proposed CRT, complaint review team. They are each given information as to the identity of the LSP and the identity of the site, the identity of the complainant, and they have to make a determination on their own as to whether or not they need to be recused from any additional consideration in this matter, either because they know the person or they have a business conflict of interest. There can be several different reasons why someone might need to be recused. But if a member of the proposed CRT is recused, then they have no further actions or dealings on this complaint. They are basically taken out of the equation for any future deliberations. If they're not recused, then they get exposed to all the gory details, if you will, of the complaint and of the site. Okay, so, just to reiterate, this is the first time that any members of the board have been provided with information as to the identity of the LSP, the complainant, and the site in question. So now what does the complaint review team do? So this is a significant investigative step. And this is the work of the CRT is substantial and very time consuming. The board investigator that was originally assigned to the complaint assembles all the relevant documents for the CRT review. This is a big process, and it depends on how many sites were the basis for the complaint or a variety of things, but there can be a large number of documents that have to be reviewed, documents and data that have to be reviewed by the CRT. The CRT members review the documents, and during the course of their review, they may also identify the need for additional documents or additional information that they feel necessary in order for them to complete their evaluation. And these CRT members also can interview, and usually try to interview the LSP, to have a one-on-one, to have some questions that are that arise based on the review of documents for which clarification may be needed that to help the CRT make their evaluation. They can also evaluate other people. They can they can also interview other people, interview the complainant, interview neighboring property owners, or whatever the issue may be. There's no limit on the number of interviews that can happen, but the primary one is between the LSP and the CRT. After the documents are reviewed and deliberated and the discussions among the CRT, they prepare a report. They prepare at least one report, and that report is basically a redacted report that will go to the board for the board's review. The non-recused member of the board will review this report. And the report summarizes the facts, any extenuating circumstances, any particular information, relevant information that may have come out during the interview process, and basically summarize and makes a recommendation as to whether or not the CRT believes that discipline is warranted. So it provides a factual summary, a little bit of an interpretive summary, if you will, and a recommendation of the CRT as to whether or not discipline is warranted. If that report, if the conclusion of the CRT is that discipline is warranted, then the CRT also prepares a second report, also redacted at this time, which is a recommendation for the type of discipline. And as Beverly mentioned, a lot of work is spent trying to look at past discipline imposed for similar circumstances. You're not going to get identical circumstances, but you try and look at as many similar circumstances to come up with a reasonable recommendation for a discipline. And again, just to reiterate, the documents that are prepared by the CRT, the two reports, up to two reports that are prepared by the CRT, they'd only prepare one if they said discipline wasn't warranted. But the reports that are prepared for board review are redacted so that the people who are reviewing those reports still have no information about the specifics of the individuals that might be involved as well as the site. Now, disposition by the board. It's important for everyone to understand that all deliberations by the non-recused board members are done in a quasi-judicial session. And redacted reports are read by the board members, and again, the name of the LSP is not known, or the site is not known to the board members who are doing this review. The CRT prepares an oral summary, or presents an oral summary of the report. So the reports are provided, the non-recused members read the reports. The CRT at a meeting, quasi-judicial meeting, session meeting, makes an oral presentation of the report to the members of the board who are going to be deliberating about this matter. They are there to also answer questions. The board may ask them questions that were not, that just as a result of the oral report and having read the written report, the CRT also answers questions raised by the board. CRT then is generally excused while the board continues the deliberations or starts their deliberations on the matter. Now the board could ask the CRT to come back in as a result of the deliberations and ask a few more questions. Or the board can say, we're sort of stuck on this, we'd like you to do a little more investigative work. But eventually it's the non-recused board members who make a determination as to whether discipline is warranted, and if so, what that discipline is. So another important point to note here is that the CRT recommendation about whether discipline is warranted and what that discipline is not binding on the board members that make that vote. The board members can actually modify, choose something different than what the CRT recommends. But there are two possible outcomes. One, no discipline is warranted, and if the outcome is that, then the case is dismissed. Or that discipline is warranted and what the recommended discipline is. And if the conclusion is that discipline is warranted and a certain type of discipline is to be imposed, then we move into what are called the formal adjudicatory proceedings. And the first thing that happens is that the LSP is notified, I'll say it's the first thing. first major thing. The LSP is notified by the board with an order to show cause as to the allegations, basically an order to show cause as to the discipline that's been imposed and the basis for it. The order to show cause explains the basis for concluding that there was a discipline is warranted, as well as the basis for recommending the type of discipline that is recommended. And then there's two outcomes at this point. If the LSP does not dispute the order to show cause and accepts it, then the board can just impose the discipline. So it's essentially discipline imposed by agreement. Or, I failed to mention this, the order to show cause gives a time frame by which the LSP must respond. If the LSP does not respond within that time frame, then discipline can be imposed by the board at that time without any further proceeding. If the LSP challenges the order to show cause, then there is a formal judiciary hearing, formal disciplinary hearing, and the hearing would be presided over by a hearing officer from the Office of Appeals and Dispute Resolution. And at the conclusion of that hearing, that hearing involves pre-filed testimony, written testimony, it involves actual testimony by key players, it also involves witness testimony. And then the hearing officer will make a recommended decision based on what they learned during that hearing. And then the recommended decision, some or all of the conclusions in the recommended decision can then be incorporated into the final decision, which is prepared by the board attorney. The final decision contains the final facts and rulings of law and the board's final order of discipline. And again, it is based in part on the recommended decision of the hearing officer. It's not an exact verbatim translation of the hearing officer's recommendation. Now this is where I'm going to stop talking about the complaint review process. The final decision is really not the end of it because there could be an appeal process, but that's something that is basically out of the hands of the board. There can be additional formal legal actions taken, but that's not part of the complaint review process. So, a couple things to note here, key points that we, the board members, would like the LSPs to know is the one that the board is independent of Mass DEP. We do our own independent investigation. We rely on information provided by a variety of sources, including the Mass DEP, but we are not a parrot, if you will, of the Mass DEP. The investigations are thorough. All of us who have been involved in CRT process know that we have spent a lot of time reviewing a lot of documents and discussing it. The complaint review process is designed to be as protective of the LSP's identity as long as possible. And the LSP identity is unknown to the board members who are voting on whether or not discipline is warranted and what that discipline is at the time they're making that vote. And another thing is that settlement can be negotiated at any time during the complaint review process. So as the process goes on, just as is any sort of legal or quasi-legal process, both sides can agree that maybe we should settle this rather than continue it in an adversarial session. So that can happen at any time in the process. So at this time, I now would like to turn it over to Gail Batchelder, who will discuss types of discipline and give you some information about discipline that's been imposed in the past.
Thank you, Jack and Beverly, for setting the stage for a part of the talk that is maybe of particular interest to some people, just because it may seem straightforward, but in fact there's some interesting aspects to what's gone on in the past. So, oops, I gotta hold on. Bring the mic down a little.
Did you see the?
Bring the mic down. Will that work? Does that work for everybody? I gotta find the arrow key.
Oh, you overshot?
Got it? I'm good.
They're tiny.
I'm good. Okay, so there are several types of discipline that are authorized under the LSP's regulations, and they're set out at 309 CMR 7.02. Four of those are specifically in 7.021, and those are the private censure, the public censure, the suspension, and the revocation. Other sections of 7.02 allow for administrative penalties. The one that is not included in that section is the voluntary surrender, and I'll talk a little bit more about that. But what I want to talk about specifically is go through the actual types of discipline, even though right now they have not been used that frequently in some cases, but that doesn't mean they might not be used in the future. So I want to first talk about private censure because it's a very interesting situation in that the private censure was designed to be the least harsh of all of the disciplines that could be imposed on LSPs. However, what that means is that nothing about the case can ever be made public. And that means that no press release will ever be issued. But it also means that when there's if you click on the searchable list, you can find out any disciplinary actions about an LSP, and all of the disciplinary actions come out except this one. And what it says is, please contact, right now it says Beverly Coles Roby. Now, that can be a little disconcerting, because now nobody knows what that means. And Beverly can't give them any information because none of the details can be made public, so it's left to everyone's imagination. Well, it turns out that at one point an LSP actually asked specifically, having had this, he already had one private censure, and found out what that meant, and when another one was up and coming, he said, you know, I don't want that. Just give me a public censure because it's a much worse situation to have people wonder what might be coming. So I think that's something the board could look into as to how much, maybe it's just say, it's a private censure, because we don't even say that. And so if you said that, people would understand it a little bit better because they understand the difference between public and private. But it's still problematic, and so it hasn't been used. And the other reason it hasn't been used is a lot of times the types of cases where it would be used just aren't coming to the board. DEP is being much more sophisticated in recent years. This was something that maybe in the beginning it might have been more frequent, but those kinds of situations haven't arisen recently. The next most serious type of discipline is the public censure. And usually when the board imposes a public censure, it's a situation where it's a relatively straightforward complaint to resolve. It usually involves maybe one site or a very straightforward situation. For instance, the LSP violated RAM plan provisions or didn't file a RAM plan when they should have. Well, it's a clear violation of the MCP. There's nothing the board can do once it comes to their attention. They can't just ignore it. Something has to be done. And that's the kind of situation that really where a public censure works extremely well. A public censure is in fact public, the details can be provided, and when it is imposed, there will be a press release. I'm going to skip over the voluntary surrender for a minute and come back to it, but the next most serious discipline that can be imposed is the suspension. And the suspension can be anywhere from 1 day to 5 years, and 5 years is the most time that the board can take away a license. And one thing I wanted to mention, because somebody asked me to, is that if you have a suspension of less than 90 days, you do not have to notify your clients. But anything over, like 91 days, and your client has to be notified that you don't have your license. Obviously, DEP would have to be notified for anything less than that, but you don't have to notify your clients. So it's really important thinking about the suspension, because the really key piece of a suspension versus a revocation is that at the end of the suspension period, your license is reinstated as long as you've met the other conditions for that discipline. And the other conditions that are most often imposed by the board are the requirement to take continuing education classes. And generally that's a situation where the board really believes that the LSP could benefit from that. It isn't like adding a harshness to the penalty. It's that the board really believes that with that, the LSP will come into compliance much more easily. And generally specifies the type of continuing education or the subject matter for the continuing education, and requires that the LSP have the board or the CRT approve a course to make sure it meets that criterion. And those courses are over and above the coursework that they need to renew their license. One other thing that the board has imposed along with the suspension has been the requirement to retake the exam. Now, the difference between that and the revocation is that in the revocation, you have to reapply, but in this case, you will be reinstated once you've taken past the exam. So that's a very big difference, and that was in a situation where it was a little bit more harsh, and the board wasn't sure that the LSP really did understand enough of the MCP and thought it might be a wise idea. There is one other aspect of suspension that's called an immediate suspension. And immediate suspension is really reserved for the most serious cases. And it's used in a situation where the board believes that if the LSP were allowed to continue to practice during the disciplinary process, which can take, as I'm sure everybody has heard, can take years, that the public would be at risk. And so there was a provision for an immediate suspension, but the LSP has 7 days in which to appeal that decision and have a hearing before the full board to decide whether or not that truly is warranted. But that's not, the immediate suspension is not a final decision. The disciplinary process will proceed. It just means that the LSP doesn't have their license during that period of time. The revocation, as you might expect, is reserved for the most serious complaints. They're complaints that generally almost always involve multiple sites, multiple violations at multiple sites, a pattern of noncompliance, a pattern of practice that really demonstrates that there is some reason why this person really probably should not be practicing. The revocation can last for any period of time. They're usually quite long. I'd say 3 to 5 years is generally where they've ended up. And at the end of the period, the LSP would have to reapply. And administrative penalties are something that has also been rarely used, but it has occurred. And there are provisions in the regulations at 39 CMR 8 that talk about administrative penalties and what the board can and cannot do under that framework. I do want to now go back to the voluntary surrender, because that's something that really came about in the middle of the period the board has been operating. And it's not actually a discipline that the board can impose, because it's not listed as one of the disciplines. It's something that the board came up with as a way to resolve complaints where an LSP particularly didn't want to accept and agree to as a settlement either a suspension or a revocation. And I believe that's probably for insurance reasons, because they may ask, has your license ever been suspended or revoked? And if you voluntarily surrender your license in lieu of discipline, which is how we used to phrase it, you would not be legitimately able not to have to answer yes. So I think that's how it came up. It has turned out to be a very easy way for the board to resolve a lot of complaints that otherwise would go on to be adjudicated, take up a lot of board resources, a lot of stress on the LSPs, and it's a relatively simple solution. Generally, when a voluntary surrender is the option, it will have in the consent order some length of time before the LSP can reapply. That's part of that. And I want to point out that most recently it seems that the vast majority of the complaints have been settled via consent order. And so I think the word is getting out that it is actually a good alternative to seeing the process through. So let me just get underneath all this and find that slide again. Okay, so I'm going to spend a little time here because this is actually kind of interesting. When I started going through all this information, it turned out to be kind of cool. So there's a lot of numbers on there, and I'm going to try to break them down to be a little bit more user-friendly. But what isn't on there is the fact that so far there have been 147 complaints filed against 100 LSPs, different LSPs, and 10 non-LSPs. What that means is been 137 complaints against LSPs. 71 of those complaints have been filed by DEP. And that means that just over half of the complaints against LSPs have been complaints from DEP, which means a lot of complaints from the public. So I do want to point out at this point that the reason that it's 147, and if you notice those numbers, they add up to 142, is because there are currently 5 active complaints. So we haven't, but we have that, basically 142 complaints have been resolved, but they've been resolved as a result of 133 separate actions, which should also clue you in that there's another number floating around. And that means 37 LSPs, and that's roughly 27% of the LSPs that have been the subject of a complaint have been the subject of more than one complaint. So, and that's actually quite a few if you think about it. In some cases, it's one or more of the complaints have been dismissed. This is how it happens. And that's either before or after an investigation. And in other cases, the LSP may have received more than one form of discipline. That also complicates all these statistics. So that in some cases, they received probably the lower discipline the first time, like a public censure, and by the time the second complaint comes in, the discipline's going to be a little bit more harsh. And you also have to look at the fact that there was another complaint to start thinking about, is this a pattern of practice or something like that. So 9 actions have been resolved. 9 specific actions have resolved more than one complaint. So sometimes what the board does, because of the timing of when complaints come in, sometimes sometimes a complaint gets resolved before the second one comes in. Sometimes you have one coming in, about to be resolved, and then another one comes in. And it's just easier to help resolve the complaints by combining the 2 complaints as a case, really. And the resolution would take into account both of the situations and the fact that there's 2 situations. So all that is taken into account. So 45, and this is where it gets kind of interesting actually, 45 of the 147 complaints were dismissed, or actually 142 because they've been resolved, were dismissed either before they reached the board, and that's, as Jack indicated, is because the nature of complaint was outside the board's jurisdiction, like a fee dispute or something like that, or they were dismissed after the initial discussion by the board based on the redacted complaint and response from the LSP. So, and in that case, the board is making that decision based on the fact that after reading the redacted version of the complaint and the LSP's response, they felt that it either didn't rise to the level of board action or it was pretty straightforward what was happening, or again, they decided it might not be within their jurisdiction. But here's a really interesting piece. The 29 complaints were dismissed after being investigated by the CRT. And what that means is that almost 30% of the cases that have gone on to be investigated by a CRT have actually been dismissed after the investigation was conducted. So it means that even if you get to the point where you have a CRT, all is not lost. There's, after investigation, it is entirely possible that the case will be dismissed. As Jack mentioned, you have a couple of different types of resolution after it's been investigated. One is the dismissal. You can either have a consent order for discipline, and as I mentioned, that has been, by far, most of the complaints have been resolved as a result of consent orders. Or you can go on through the adjudicatory process. And I think, I did want to say one thing that's kind of interesting. You notice that there were 10 non-LSPs for which there were complaints. And generally that's for things like somebody is complaining either because they don't understand that you can't do anything, or because somebody is holding themselves out to be an LSP, and that is a violation. They either have LSP on their business card or in some form of advertisement. The board actually has no jurisdiction over imposing discipline on those people, but they do have the ability to refer those cases to the strike force or some other appropriate place for resolution. All right. I think I'm doing okay on time, am I not? All right, so in terms of the types of cases that often result in discipline, First of all, it's pretty much as you would expect, that the more severe the case is, or the more complicated and the greater number of sites involved, the higher the level of discipline. But I want to make one point that Jack actually touched on, and that is the fact that, I think Beverly did too, actually, that basically the board works really hard to look at the past when deciding what any given case might be, what discipline might be appropriate in any given case. And now we really do have a lot of cases. This was a lot harder when you only had 10 to work from. But now we have a pretty good body of casework to be able to look and say, well, this fits within the pattern of a suspension of X period of time. What changes, though, and makes every single case different is that it's a different site. It's a different allegations. It is different mitigating factors or aggravating factors. So there's no one cookbook approach to picking a discipline. And what complicates everything a little bit more is that a lot of the decisions that have been made on settlement situations have been settlements. The board has given up something that they wanted to get the case resolved and have everything move along. So sometimes when you're looking at something, well, that person only got, a 2-year suspension for these allegations, why are you recommending that I get 3? And some of it's that's the reason. Because there were aggravating and mitigating factors which would actually be identified so that the board could look at those, or it's just a matter of it was better to get the 2 years than not, and then just go through that process. So I want to keep that in mind for everybody when we talk about this, that there's no real answer, but you have a range that seems reasonable for the situation. So, for instance, if you want to talk about the easiest ways to look at it is a very straightforward violation is something that a RAM plan should have been submitted and wasn't. You can't ignore it. It's very easy. And a public censure is appropriate because it was so obviously a violation of the MCP. Another public censure might be something as simple as there are, you have 2 sites, you did kind of the same thing on them, but they weren't at the level where at this point you were going, that really a suspension was warranted, but maybe the LSP would recognize by getting a public censure that that's okay. Generally, there's no real need to go into the LSP's record and look at more cases because it's pretty straightforward on how to handle it. However, there are times when it's to the LSP's advantage for the board to do that. Because if you have one single situation and the rest of the record looks fine, then you're more likely to end up with, maybe a dismissal with a warning is okay this time, because generally they do things right. And so all of that goes into the thought process. But the real serious situations are those where there are patterns of noncompliance consistently. It's more than one site. And in recent years, DEP has gotten very good about only sending cases to the board that generally are well thought out. They're very well documented, and if they think it's a pattern of noncompliance or any kind of pattern of deficient investigations, they will lay them all out in the complaint itself. So the board is not doing that on their own. They have it in front of them. They may want to look at others and see if are these the only ones and the person does 200 sites and you're talking about 3 or something like that. But generally, we're getting more comprehensive complaints from the DEP. And the public, you just take what you get, and then sometimes you have to look for patterns based on what the nature of the allegation really is. So there are cases that involve multiple sites, there are cases that involve multiple violations at multiple sites, and patterns of noncompliance. But the cases that have resulted in the highest level of discipline are those where the risks, or the greater potential risks to the public and the environment have existed. And I want to just go over a couple of different situations like that because there are definitely patterns in what the board has seen in that regard. For instance, I'd say the three main topics of vapor intrusion, water supplies at risk, issues with risk assessments, and in some cases, contamination in surface soil that wasn't addressed. And the kinds of things that the board would look at is whether the LSP failed to collect the appropriate samples, for instance, failed to perform and investigate, this for vapor intrusion, for instance, failed to perform a sufficient investigation to demonstrate that vapor intrusion pathway is not a concern, or that just failed to recognize completely that the pathway was a concern. When it comes to water supplies, it's very often the failure to delineate the extent of contamination and to demonstrate, specifically to demonstrate that a private or a public water supply is not at risk. And that means that they didn't adequately characterize bedrock or deeper overburden or something like that. Sometimes it involved not sampling private supply wells because they were off-site. And the other thing that has come up more than once, certainly, is that inappropriately concluding that like a groundwater divide exists between the site and the property, or that there's no hydrologic pathway that connects the site and the receptor, and without the sufficient documentation to support that conclusion. For surface soil, obviously it would be inadequate characterization in areas where the potential for direct contact would be greatest. For instance, at a public park, something like that. And the contaminant is PCBs, you know? And yes, it has all, you know, all of those things have occurred, and it's hard to believe sometimes. To get to Beverly's going, well, who would do that? And sadly, people do. But the other thing that I don't think people realize as much is that sometimes it's the risk assessments that cause the problem, and that's when there's inappropriate data or inappropriate assumptions used in the risk assessments that the LSP should have recognized. And the board understands LSPs are not risk assessors, but there's an assumption that LSPs are supposed to know certain things about risk assessments as part of their job. So, the things that the board would look at are those things that are so obvious that it's very hard to deny that you should have known them. And things like there's insufficient data to adequately characterize the risk, which means there's insufficient data to actually characterize the release. Sometimes it's a case where not all appropriate data was used in the risk characterization itself, even to the point where it appears that certain data is excluded from the risk characterization. And then the other issue would be the improper identification of pathways or the dismissal of certain pathways without the data to support that. So those are the primary, I hope that gives you an idea of the kinds of things that the board is looking at when they're looking at how they determine discipline. I don't know how we're doing on time. Michelle will tell me whether we have time for a case study.
Sure, yes.
Well, I had two choices at both ends of the spectrum, which is really interesting.
Just make sure you're close enough to the mic. I don't
Push
know.
that mic over, yeah.
Okay, this way?
Yeah.
We good?
Yes.
Okay.
Yeah.
That's a little much for me. Okay, so the first one I wanted to do, and I apologize, I'm not going to do it from memory. I'm going to do the simple one first because it's really kind of fun. And that's the one for the administrative penalty. Because we only had one or maybe two. And it was an interesting situation altogether, and it's a good one for people to be aware of, I think. But in this case, an administrative penalty of $1,000 was assessed in association with a public censure to resolve a complaint that was brought by the LSP board against a supervisory LSP. It was shortly after that regulation was put into 309 CMR. And that is that, and I don't know if you know that, but an LSP was involved in the management or review capacity disposal site will be considered responsible, along with the second LSP, for the second LSP's violation of the rules of professional conduct. And then there's some provisions for the situation in which that can occur. But in this case, during the investigation of a complaint from DEP that an LSP had violated the MCP by conducting response actions associated with the removal of a large underground storage tank, that should not have continued past a specific point due to the conditions of an LRA having been exceeded by volume of soil and removal of groundwater. And so the board was investigating that complaint, and after multiple email and telephone discussion, the board discovered that the newly minted LSP, this is a person who just gotten their license the month before, and had just started working for that company. And he had actually expressed concern in internal meetings that it shouldn't have proceeded, that they should be doing something about it. But he wasn't in any position to actually stop the job. So finally, at some point, 7,000 yards later, something close, it might have been 700, it's probably closer to But once, anyway, it was a long time after it should have been decided. But once the decision was made internally that a RAM plan was necessary, the supervisory LSP, who had up until that point been the only LSP that firm had ever, who had ever submitted an opinion, actually had the new, told the new LSP to be the one to send in the late RAM plan. Exactly. You can imagine. So, so what happened is the board decided, knowing about this rate, and this is actually the reason we put it in, is because I think everybody felt that same response, is that the person didn't have a choice, and we could see that. And so we decided to file the complaint ourselves against the supervisory LSP and investigate that aspect of it, which we did. We felt that, and it was clear, I mean, there's plenty of email trail and everything else that he knew the situation. The board felt that because it was a willful knowledge, I mean, he actually ordered somebody to do this thing that he knew was a violation and didn't do it himself, that we felt that suspension of some period of time, didn't have to be long, but a suspension was really appropriate in this particular case because of the nature of the violation. But he absolutely adamantly refused to accept that, and obviously it would have been a very long, drawn-out procedure. So we negotiated, and we felt that a public censure just wasn't quite enough because it wasn't fair to the other people who had gotten public censures for something that wasn't that straightforward and obvious and willful. So what we did is the first time we also imposed an administrative penalty. The LSP actually agreed that $1,000 was the maximum we could impose. So we agreed that we would settle for the public censure with a $1,000 penalty because it made the point that this is more serious and slightly different from all the other kinds of public censures that we had. And that was kind of an interesting situation. Now the other one is, if we have time, yep, okay. So the other one is really kind of even more interesting because of what Beverly said earlier, which is, well, no one would ever look at, not look at somebody else's work if you're going to take responsibility for it. Well, it's really important to understand that that has happened a lot. And there have been many, I would say several complaints where the LSP has signed off on work that they clearly that they couldn't possibly have reviewed. And I think that's more of a big deal than you think, at least in the past. I'm hoping that perhaps that's changed as people become more aware of the fact that it's not going to fly and somebody's going to say something. But in this case, it was in response to a Mass DEP complaint that included several sites to support an allegation that the LSP's work at multiple sites was deficient and could have resulted in risk to the public and the environment. The board determined in the end that the LSP had failed to exercise appropriate oversight regarding the work performed by other environmental consultants at 5 sites. Here's the interesting piece. At least 2 of the other consultants were former LSPs whose licenses were revoked for, among other things, substandard work, failure to properly delineate nature and extent of contamination, and or conduct appropriate sampling to evaluate risk to the public. Okay, so and it was, there were sites where there was a gas station and gasoline was released to the soil and groundwater was migrating in the direction of homes. And the prior LSP had actually tried to close out the site without investigating whether indoor air at the residences might have been impacted by gasoline vapors. After an audit, Mass DEP required additional investigations, including indoor air sampling, at 2 downgrading properties. The successor LSP, who is now the subject of this complaint, subsequently signed an opinion to close out the site, having overseen apparently overseen additional work by the LSP whose license had been revoked, but no indoor air sampling was ever performed. And in addition, DEP found additional deficiencies because the extra work wasn't adequate to come to a conclusion that there was no significant risk. The other site was very similar in that there was the gas and contaminated ground was likely to migrate nearby the residential dwellings and discharge vapors. And this was another situation, it was another LSP, where the license for the other LSP had been revoked for substandard work. It was the same situation, and this time the LSP, the successor LSP, submitted an RAO without conducting the evaluation required by the Mass DEP. They'd already told them they needed to do it to evaluate whether the residents were protected from risk due to vapor intrusion. In all 5 of those sites, there were similar types of deficiencies and noncompliance that were identified, and it was even evident because we actually knew the prior LSP and had seen the work. We knew that this successor LSP had actually just signed. I mean, it was the same person's work with the same typos in it, the same letterhead. You know, I mean, you actually knew that there had been no real review or editing of this. And in addition to those 5 sites, there were also 2 sites that the LSP did on his own that were also similarly deficient. So here's a situation where normally, had it proceeded, the board would have probably, I mean, certainly revocation was on the table. It would be an appropriate situation for that. However, that was not acceptable. I mean, it would have been appealed, we were told that. And so we tried to come up with a solution that would work, resolve the complaint, protect the public, and yet save board resources and allow us to handle some of the other complaints. So what was finally agreed to after much, actually less in this case, what was finally agreed to was that the LSP would voluntarily surrender their license. This was one of the first ones where we actually did that as a solution. So they voluntarily surrendered their license for a period of 35 months. For some reason, they didn't want to go 3 years. We don't know why, but we decided that we didn't care. You know, 35 months and 36 months were the same to us. And but the consent order further stipulated that to become licensed again, the former LSP will have to reapply and take the LSP exam, which was a given anyway. I think it had to do with there was a 3-month window or something. I think at the time, I'd have to go back and look, but that may have been the issue. But we just said, no, you're going to have to take the exam anyway. And so that was the resolution. So the board has tried, I know sometimes it doesn't seem that way, but we really do try to come up with creative solutions that will be acceptable to both the LSPs, the public, the board, DEP. You know, DEP doesn't play into it except that they are the ones that end up having to compile the complaints for the board if there are patterns of noncompliance, and it doesn't make sense to waste department resources either in doing something like doing the same thing over and over again. I think it's time for questions, if I'm not mistaken.
Yes. Yes. Thank you. Thank you, Gail. Gail, if you haven't read in the materials, has been on the board since 1997. I think you're probably the longest serving board member at this point, right?
Show you.
She's probably dying to get off too, but anyway.
I thought you were the shortest.
Yeah, the short. Oh, what no. Anyway, the board member going or not.
Jack's the tallest.
But thank you. Actually, I think LSPs in the Commonwealth are fortunate to have people like Gail and Jack who volunteer their time, and the other members who are here who volunteer their time to serve on the board, because it is in addition to everything else they do in their professional life. Although Gail's been on the board since '97, Jack has only been on the board since 2008, right? So actually, there has been a fair amount. I mean, a lot of the folks were on the board for a long time at the beginning, and then That's changed, and there have been some more recent appointees in the last several years, so that's probably a good thing as well for everybody, including for board club purposes. So we want to allow some time for questions. We still have 10 or so minutes before our hour and a half is up. I'm going to actually give this to you all so that you can hand this portable mic to whoever is the appropriate person to answer the question. I don't know if anybody has any questions written down on the index cards. If so, please hand them up. And otherwise, I'll take questions from the floor. And I'm not going to start with you, Elliot. Thank you. Because I thank you. All right, start that stuff. I wanted to just ask, I think quickly, I think what I heard you say, Gail, is something about, and this was part of the presentation as well, that during the CRT, during the complaint review team investigation, the board investigator assembles relevant documents, and my understanding is that the board is not only looking at the complaint and the particulars of the complaint, i.e. that site and whatever was going on with that site, but actually does some investigation into other submissions by that LSP. So I want to know from whomever, is that true? And if so, why? Gail wants to take this.
Okay, and then Jack can weigh in. I think basically that that's partially true. And as I said, it depends on the nature of the complaint that comes in and whether there's any reason to think that it's either a pattern of noncompliance or alternatively, is this just a one-time thing? And it goes both ways. Is this just the kind of thing that it's a real, difficult client, it's one time that this has occurred, it's really not fair to for an LSP to get a really harsh penalty, especially when it's not the direct violation of the RAM. I mean, you can't avoid those kinds of things, but when it's just a question of it's inadequate characterization or something, it's really actually better for the LSP if the board actually checks out a few other sites, a few other NOAFs and finds out that no, this is the only one. It's much more likely to result in a dismissal, and that's kind of where a lot of those dismissals have come from, is because the board has looked at other sites and said, this clearly isn't representative of the LSP's work. And so I think it does work both ways. And now that the DP is handing us more of the patterns, we don't have to do that much more. The only thing we might do is say, especially when they give you one that's 6, you don't want to look at more than that generally. So that's my thought on that. I think it definitely has worked to the LSP's advantage when the board has done that.
Jack, any additional?
Well, I guess my thought on it is that I think when we've asked for, at least ones I've been involved, where we've asked for additional information, it's to seek to determine whether or not the aspect of it, for instance, a NAPL investigation, a DNAPL investigation, whether this is a fundamental lack of knowledge that the LSP has, and that's why we need to look at other sites, or whether it may have turned out that it was just I'll call it an oversight at the one-time thing. But I think where we've asked for more site information is where, failure to sample indoor air frequently, or failure to understand the hydrodynamics of NAPL migration.
So one question I received is, and I don't know if you have the statistics, because you have a lot of them, yeah. How many complaints initiated by a DEP are dismissed at the initial review stage?
I don't think we have that as
Probably.
almost. No, we tried it once. I actually can tell a story about doing that once.
We don't have time for funny
Yeah,
stories.
yeah.
Sorry, later.
So anyway, no, I would say
They don't have that information. That's the answer.
No,
That's okay.
Now, I would imagine
Right, no,
that
we
if
did.
that
It's a
means
long
initial stage, if they mean
Yeah.
outside the jurisdiction of the board, I
No.
doubt there'd be any filed by the DEP in that regard.
No, but I think
Oh, before the
before a complaint
CRT
review
is
is
formed, okay,
right.
I don't know.
Okay. Question from the floor, Elliot?
Gail mentioned that in evaluating the penalty, or evaluating whether they violated the regs. They looked at past patterns of compliance and past complaints. I was impaneled on a criminal jury, and what was interesting that during the trial, it could not be disclosed whether the person had been convicted of a prior offense. And it wasn't until after the jury came to a finding that the prior history came out. So why is it you can look into past violations before coming to a finding, and you can't do that in the criminal court?
I'm gonna let the
Should
lawyers
I repeat
handle
the
that.
question for folks in the back here, the question?
No.
Yes, no, but come on, did you hear it? Some people didn't, some people didn't. So just quickly, I'll paraphrase what the question is in a criminal case, the jury cannot hear about, and there are some exceptions to this too, obviously, but a jury generally doesn't hear about past convictions of the defendant in that particular case. So the question is, why is it that the board can look into past history practices of an LSP as part of its investigation?
Well, first of all, a criminal case is very different from what the board is dealing with. In a criminal case, clearly someone's personal liberty is at stake. And so hearing about past bad acts might influence the jury in a negative way. It could have a prejudicial effect. And so the judge would exclude any evidence that might be prejudicial to the defendant's case. With respect to the board, it's kind of the opposite, because knowing of a pattern or a practice of doing the same thing incorrectly or against the MCP over and over again makes you an LSP who poses a larger risk of danger to the public.
Does it comply with the law?
Does it comply with the law? Yes, it does. The adjudicatory proceedings are handled with respect to any evidentiary hearing. So the evidence that goes in is weighed by the presiding officer in terms of its prejudicial or bias, any effect that it might have on the outcome. But a criminal case, I think we're talking about apples and oranges. I really think they're very different. It's not the law with respect to the LSP board, though. It's the law with respect to criminal proceedings. And I think that I know that the rules of a civil case are very different than the rules that apply in a criminal case.
And these are adjudicatory proceedings, not judicial, so that's another reason why there's a distinction. I'm not advocating one way or the other, I'm just saying,
Yes.
so to speak. So there is a question, Beverly, and I know we have a couple of other questions out there, but I think quickly, because I have one here, a question about presiding officers. So their experience, could you just describe a little what's going on with who's actually hearing these days?
Sure. I was a presiding officer in the Office of Appeals and Dispute Resolution. It's a separate entity from DEP. They are physically housed and paid by DEP, but they hear appeals of licensing decisions and permitting decisions by DEP. And what the board decided was that the cases that were going to the Division of Administrative Law Appeals, another separate administrative agency, was over.
That wasn't my question, but you're looking at me.
Oh, okay.
I knew I should have That's my last question.
I was thinking general. I probably should have done it turned around, that would have been better. But it's the OADR hears the case. They have nothing to do with DEP other than rendering decisions on evidence that they hear. They're separate from the board. It was a good fit for us because the cases would go directly to OADR. We knew where they were going. We could estimate how long they were going to take. to go through the process. They were only a floor away, basically. So it wasn't necessarily a convenience, but it turned out to be for all concerned. Once the case went to DALA, as they were in the past, the Division of Administrative Law Appeals, the board basically lost all control over time constraints and time management with respect to processing the cases.
And I'll just add, editorial or otherwise, the administrative law judges at the Division of Administrative Law Appeals didn't necessarily have a substantive understanding of what you all are dealing with as LSPs. Whereas the Office of Office of Appeals and Dispute Resolution presiding officers have more of an understanding of the MCP and issues that you deal with as an LSP.
And they are all lawyers.
Because they're lawyers who came from DP ranks, if you will. So we only have a couple more minutes. Questions back to
I think it was Gail that mentioned the different levels of discipline, and a couple of them, the revocations and long-term suspensions, would be followed with a stipulation that you have to reapply, like take the test again and reapply. Just curious how many of the people who have gotten to that stage have just basically dropped off and say, okay, why don't I just do something else versus going through the process and getting back on the same level.
Okay, to date, and somebody else can correct me, but I know we have one person who has come back into the profession after losing their license, and we had another person who thought about it, applied, but they didn't have the relevant experience for that 3-year period. There's a clause or a section in the regs that says you have to have 3 of your last 5 years have to be in responsible charge, and they did not have that.
kind of hard to do when you don't have a license.
Well, no, just like anybody else who doesn't have a license.
Sorry. Okay, so,
That's what I'm saying. I said
so
that.
for folks who are paying attention to the time and need to leave and want to leave, it is 8:15, so the hour and a half is up. I guess I'm going to offer, unless I hear otherwise, from LSP board members who are here, if people do have other questions, want to come up and ask, feel free to do so, or if people want to stay, I mean, we can stay a few more minutes, but I want to be mindful of your time, obviously. Thank you all.